Today I'm going to look at a case or two in causation in English criminal law, and I'm going to examine this idea of external and internal causes. So let's think, before I look at the cases. The case I'm going to look at Rebelo and Field, two decisions from the Court of Appeal in 2021. Let's first think about external pressure and internal pressure. If I put a gun to someone's head, that could cause them to act with a significant degree of involuntariness and do something they don't want to do. But they might also have mental illness, and that could be an internal cause, causing them to act in a way they don't really want to act. We see this actually in Dostoevsky's character Raskolnikov. Dostoevsky's great book, Crime and Punishment, this character is a law student who's studying law in St. Petersburg in the 19th century, and he's hungry, he's suffering from poverty, he's out of money, and he keeps pawning his items to a moneylender, an old woman who he thinks is not a nice lady and whom he thinks he deserves her money more. So he sees these barrels of money each time he pawns something and decides to murder her and take the money. But the external cause for Raskolnikov's behaviour is the fact he's suffering, he has no money, he has no job, there's no welfare in 19th century St. Petersburg, and he's starving. So it's duress of circumstances, his poverty. But it's not going to give him a defence for murder, because duress is no defence to murder, and also the threat of hunger is not a sufficient threat. But Dostoevsky's also trying to get us to think about Raskolnikov's other causes. Another cause internal to Raskolnikov, who has mental illness. There's some sort of mental disorder. This is strongly implied throughout the novel. So the internal cause for his behaviour, his internal cause, the mental disorder, external is the duress of circumstances. So let's think now about Rebelo. Rebelo involved a diet pill business, an online business owned by Rebelo and another. And what he was doing was simply supplying people with diet pills, but the pill he was selling was dinitrophenol, which is an illegal substance, cannot be sold. There's regulations against it, and it's also banned by the Food Safety Act 1990. He sold this to a woman who was about 24 years of age. She's a first-class honours student at university. She's warned by her doctors, by her parents, by her tutor at university not to take the dinitrophenol because it is a dangerous substance. It's dangerous in that it's been empirically shown that it can cause organ damage. It's not dangerous in the sense that it is shown to be a drug that carries an obvious risk of death. So one point in the case of Rebelo I disagree with would be that finding that dinitrophenol carries an obvious risk of death, which is a core requirement, a core element in the offence of gross negligence manslaughter, which is a crime that Rebelo was convicted of. I don't think that was supported by empirical evidence because dinitrophenol has been around since the 1930s. It's been used by at least 1 million people. There's only been 6 deaths. So it seems that we need evidence to show that it is a drug that carries an obvious risk of death. The evidence was not there. So I was surprised that got past Dame Victoria Sharp in the Court of Appeal, that point, and it was accepted because the barristers could have pushed back a little bit on that, counsel representing Rebelo, and simply argued, well, there's no empirical evidence to show this drug carries an obvious risk of death. But let's think about the internal and external causes here for the involuntariness, because the core decision that needs to be applied in these causation cases is Kennedy number 2, which holds that a chain of causation is broken if the person intervening, so the intervening act is by a human agent who is fully informed and makes a voluntary choice to do the act that ends up causing the end result. In the case of Rebelo, the victim had taken the dinitrophenol herself. She was fully informed that it was a dangerous substance, and yes, her decision was not fully voluntary. And Dame Victoria Sharp was careful to emphasise that and made the point that voluntariness comes in degrees. So in causation case, we don't need complete involuntariness, we don't need automatism, we just need to show there's significant involuntariness and it was caused by the defendant. So it has to have an external cause, and that external cause needs to be the defendant. If it's caused by an internal cause such as mental disorder, then the defendant needs to be the cause of that mental disorder. In the case of Rebelo, the defendant merely supplied the drug. He did not put any pressure on the victim to take it externally, and he certainly wasn't the cause of her internal conditions, which was mental illness. So the actual cause for her partial involuntariness in her decision to take this drug was the fact she suffered extreme body dysmorphia and a number of other mental disorders, and it was these internal causes that kept her taking the pills, compelling her to take these dangerous diet pills, even after being warned by her doctors, her family and friends that she was damaging her organs and was even risking a remote risk, but there was a risk of death, and she did in fact die. But she died, the night she died, she'd taken 4 pills instead of the recommended 1, and this clearly also is the causal reason she had died. So, we have Rebelo. He's being convicted for gross negligence manslaughter, and Dame Victoria Sharp said not only was there an obvious risk of death, even though there's no evidence supporting that, that he also caused death, and that he basically was just accepted he was the cause of her involuntariness. There's no examination, the idea that actually he'd done nothing to cause her involuntariness, her partial involuntariness, at least in taking the dinitrophenol. We can compare this to the case of Roberts, a 1971 decision where Roberts was giving a woman a lift home from a party. They'd only just met at the party, she hadn't known him before, and he started making sexual advances and then started trying to remove her clothes whilst driving along the road, and in terror she jumped from the moving vehicle. Clearly the external cause of her action, her act of jumping from a moving vehicle and suffering actual bodily harm, was Roberts' conduct. Roberts put the pressure. He was the cause of her involuntary acting. It wasn't fully involuntary. She wasn't an automatism. It wasn't a case of automatism. She was not an automaton. But there was substantial involuntariness, sufficient at least for making out causation, and he was the source. Likewise, in the 1983 decision of Paget, in that case, the police shot at a man and killed his pregnant girlfriend, who the man was holding as a human shield. The only reason the police shot at him is he was shooting at the police whilst they were trying to apprehend him. He's a dangerous armed man in a public place. And the police, again, partial involuntariness, not complete, but it was the cause of that involuntariness was the defendant's actions of shooting at them. So these cases are different to Rebelo. The cause of her involuntariness in taking the drug, her involuntary choice, or at least partially involuntary choice, was her own mental disorder, and there's no chain of causation. So the decision's wrong, and Rebelo should not be in prison. He's not committed gross negligence manslaughter. He's committed a number of other offences, supplying banned products, and he was rightly convicted of that, and that's all he should have been convicted of. The other case I want to briefly look at is the case of Field, also a decision from 2021. In the case of Field, a 23-year-old man seduced a man pushing 70, told him he loved him and got in his will. And once all that had been achieved, got him married and got in the will, he worked about trying to bring about the death of the victim. He did this by encouraging the victim to drink large quantities of very high strength alcohol and by surreptitiously drugging his drinks. So he's putting a drug in the drinks and in food and whatnot. We don't get all the facts in the case. So the only issue in that case was whether the deception was sufficient that we could say the decision to take the alcohol wasn't informed. What was Field deceived about? If I ask someone to walk towards me knowing there's a big trapdoor and I'm about to release the trapdoor and make them fall to their death, and they have no idea they're walking onto a trapdoor, they're deceived. They're not informed, they don't have enough information, and they basically are not making any sort of a free and informed choice to jump through a trapdoor. They've been tricked. So was the deception sufficient in Field is all the question's about. There's nothing wrong with the way the law was interpreted in that case, it's correct. If you have substantial deception and it's a deception of a nature that prevents a person making an informed choice, then the chain of causation will not be broken. The person who's putting this deception in place with the aim of causing that person's death will be held causally responsible for the death. The only sort of delicate part of the Field case was the issue of alcohol, because the victim knew and was informed that he's drinking high-strength alcohol in large quantities and that carried risks. He was only deceived about the fact that he was being drugged as well. So the drugs were combining with alcohol, and those two were the concurrent cause. The deception as to the drug alone would be sufficient to make out causation. More delicately in that case, they also examined the idea, well, would he also have to be informed about the nature of the fact that Field was trying to kill him? Well, I don't think that was quite relevant. Field's motivation wasn't going to add much to the overall issue of deception and being informed. What really needed to be made clear to the victim in that case was you're being drugged as well as given alcohol, and these are the dangerous acts, and combined they're going to cause your death. Now, if the defendant knew that he was taking a dangerous drug and knew he's being encouraged to take large quantities of alcohol, which would be dangerous to him, well, then he would be informed. The motive really doesn't come into it, because it would be obvious to anyone if they were informed what was going on, because if you're fully informed, you know that what you're doing is risking your life. And he wasn't informed in that sense. But overall, that case is really one that is about the evidence being a bit confusing, because he was informed about alcohol. Were those other things enough to make this overall decision one that he wasn't informed about? Thank you.